Morning. Apologies for being muted. I'm Nick Ashton-Hart, the Geneva representative of the Digital Trade Network. I would like to welcome you to this seminar co-hosted by the Digital Trade Network and the Delegation of Canada, Data Transfers, Storage and Personal Data Protection, what has worked in other international agreements, and how can JSI negotiators leverage these approaches. I'll be your moderator. We have a great set of panelists, including Peter Kimpian, the Program Manager for the Council of Europe Data Protection Unit, Clarice Giroux, the Data Privacy Project Lead for the Asian Business Law Institute, and Katrina Ellis-Cannon, the Deputy Director of the Services Trade Policy Division of Global Affairs Canada. We will have opening remarks by Stephen DeBoer, the Permanent Representative to the WTO of Canada. And for closing remarks, we have Alexander Mora, the CEO of TechApro Evercertia, a long-time tech entrepreneur from when he was 18, I believe, and the former Foreign Trade Minister of Costa Rica and a DTN board member. But we would like at first to have Stephen make his opening comments. So over to you, Steve.
Well, good afternoon and good evening and good morning, depending on where you are. And thank you very much for joining us today for this virtual seminar that will look at the role of trade policy to facilitate international transfer of data while protecting privacy and personal information. Let me begin by thanking our co-organizers, the Digital Trade Network, as well as our panelists, the Council of Europe Data Protection Unit, the Asian Business Law Institute, and my colleague from Global Affairs Canada. Since the launch of the Joint Statement Initiative on Electronic Commerce, there have been a number of workshops, lunches, and now webinars to deepen the dialogue among stakeholders, private sector, and trade negotiators. Canada actively supporting these opportunities to increase our common understanding of the key issues and challenges relevant to e-commerce and digital trade. Enhanced transparency and engagement by stakeholders will be key to ensure the successful conclusion of an ambitious and comprehensive WTO agreement on e-commerce. Today's focus is on cross-border data flows, an issue that is of increased relevance and importance, not only for companies of all sizes, but all actors involved in digital trade. With the current COVID-19 pandemic, digital trade has become an almost indispensable tool for firms in conducting trade and business transactions in goods and services. And while the COVID-19 pandemic has likely accelerated further growth of e-commerce, we cannot forget it has already grown quickly prior to the pandemic. International flows of data and information is and will be at the center of a global economic recovery. At the same time, it is important to ensure data flows and the movement of data is achieved while also ensuring a number of protections. A successful integration of e-commerce into the global economy can only be achieved on confidence and trust by businesses and consumers in the digital online environment. E-commerce has the potential to deliver broad economic opportunities and benefits to business and consumers. However, a fragmented approach to governing trade via e-commerce has resulted in a complex set of rules for businesses to navigate. As a result, the JSI needs to establish a strong, comprehensive, rules-based framework in the area of e-commerce and digital trade that facilitates trade, provides greater confidence and trust, but also curtails the rise of digital protectionism. Having said that, the growth of e-commerce raises interesting questions, such as how to ensure that the opportunities and benefits it presents can be realized and shared inclusively. How trade rules can provide businesses with an increased degree of certainty and predictability when conducting trade online, while continuing to allow members to employ domestic rules, including to protect privacy and security. What can we learn from past experience in balancing these issues? Today's workshop, which brings together industry stakeholders and negotiators, will shed some light on these and other questions. I'll now turn the floor over to our moderator, Nick Ashton-Hart, to introduce our panel. Thank you.
Thank you very much, Ambassador. I would, before we start with the first panelist, like to mention just one housekeeping item, pardon me, which is this session is interpreted into Spanish, English, and French, for which we thank the WTO Secretariat. If you wish to listen to a language other than the floor, please look for a little globe which says interpretation, which is in different places depending on which Zoom client you're using, and choose the language of your choice. You may also wish to mute or unmute the floor audio, depending on your preferences. I would, of course, remind everyone that interpretation works best with very good audio and for speaking slowly. So when we come to the Q&A section, please do remember to be kind to the interpreters. And with that, I will turn over to Peter Kimpian, the Program Manager for the Council of Europe Data Protection Unit. Over to you, Peter.
Thank you. Thank you very much, Nick. His Excellency, de Boer, thank you very much for having me for this seminar. I am honored and extremely patient about our discussion today on matters that are of common interest for us. With that, I would like to share my screen. Just bear with me 1 minute. And yeah, just a few more seconds and I will be able to do it. Yes, here it goes. So my name is Peter Kimpian and I'm working at the data protection of the Council of Europe. And in my presentation, I would like to shed some light on what is the instrument for the Council of Europe on the protection of personal data and privacy. Who are the members of these conventions, this instrument? What is its scope and the outreach? Why it is important for the Council of Europe member states and to the state parties to this convention? Why this could be relevant in a WTO context? And why we think that if one takes it as a starting point, even in trade negotiations, then data protection would certainly no longer be seen as a barrier to trade. So without further ado, I would like to start by stating the obvious that, of course, data protection haven't been invented in Europe or by the GDPR. It is a universal human rights, especially Article 12 in the Universal Declaration of Human Rights, which poses a positive obligation on any state to guarantee this right to all individuals. As a first binding instrument, although regional, but binding instrument on interpreting this solemn declaration was the European Convention on Human Rights, which has also in its Article 8 the right to private life and the protection of personal data. As you can see on the slide, Article 8 provides that everyone has the right to respect for his private and family life, his home and correspondence. But it is important to interrupt this flow for a minute, because it is not an absolute right. It can be restricted, and in some cases it should be restricted as well. And it was a perception that was also incorporated or encoded in our convention. As you can see in paragraph 2, that when this restriction, which can be brought to these rights for national security, public safety, economic well-being of the country, for the prevention of disorder or crime, for the protection of health and morals, or for other human rights, then that this interference should be in accordance with the law necessary in a democratic society, and and for the following purposes. Throughout the 40 years of interpreting these rights, the European Court of Human Rights always characterized this right to private life as an enabling right. So it has a special role in the jurisprudence of the Strasbourg Court, because it many times so that these rights would really be a catalyst for other rights, and in contrario, if this right is not guaranteed fully, then other rights such as freedom of expression would not be enjoyed fully. We often speak about protecting data, and we do it increasingly so when we speak about digital data and digitalized form of data. But here at the Council of Europe, we believe that behind data there are individuals, and what we mean by the protection of data, that is a protection for individuals that are based on very high level principles such as human dignity, and also the freedom of informational self-determination, which we believe becomes increasingly important in the digital age. So the instrument which lays down further requirements for member states how to uphold this right, how to guarantee personal privacy to individuals, was open to signature as early as 1981. So it did not start with the digitalization at the Council of Europe, until date, it is the only international legally binding instrument. It has been constructed based on the Vienna Law of Treaty, Vienna Convention on the Law of Treaty. It is a truly multilateral convention, open to any country of the world. If you observe the title, there is no European in the title. So as of 1981, it was meant as a global instrument for enable anybody, any country in the world to join to it. It has also become very influential during the past, and we believe that it will continue to be influential in the future as well. Just to name a few examples: OECD Declaration, human rights, to a certain extent, the APAC privacy framework document, but also in regional context, the EU data protection legislation, as well as the African Union data protection framework has been inspired by this instrument. You can see Article 23 on the slide, which enables third-party non-member states of the Council of Europe to join it, which will lead and which led to us to a current situation where we have 55 countries bound by this convention. The 47 countries of the Council of Europe, which basically covers the whole European continent, and 8 other countries such as Argentina, Cabo Verde, Mauritius, Mexico, Morocco, Senegal, Tunisia, and Uruguay. We are 2 pending accession. Burkina Faso and Costa Rica has asked the accession to this convention. Equally important fact that we have 34 observers to the committee of this convention, which out of which 25 are nation states, and with the deliberation of the convention, we took all views at the similar level into account. So there is no voting in our committee, and those countries are also participating, are given an equal footing to participate in our negotiations. So I will not prolong too much my presentation on the modernization process, which we concluded on 2 years ago in 2018. At that day, a new instrument which will modernize this convention and bring up to the speed of the digital age, the the level of protection that this instrument can offer was open to signature on the 10th of October 2018. Today, we have 33 signatures and 10 ratifications, and we believe that this amending protocol, at least for those who have ratified it, will be will be entered into force in 2023. I will not go through the articles of the convention, but I will point you to some of the articles that can be relevant in a trade context. For instance, Article 14, and you can see on the slide, and you will find more slides in my presentation that I'm sure will be available for you later on, that we have adopted a dualistic approach when it comes to transborder flow of data, which means that once we intend to create a common legal space when data can fly freely, and which basically consists of the parties, and we are eager to enlarge the membership of this convention and to create this legal space between them and this free flow of data space, similarly, by the way, to free trade agreements, if I can use this this example, where we put I had some conditions, but after that, if parties are considered that they comply with the conditions, then data can flow freely among them. And next to it, we have in Article 14 important tools and procedures to ensure that the protection that the state parties of the convention attach to the data, forward to the data, would fly with the data when it crosses border. This is the convention, and the modernized version of the convention is the result of 7 years of tough negotiations, where of course e-commerce and trade interests also have been taken into account. And I wanted to highlight you some of the elements and aspects that you will not find in other data protection legislation, at least not at regional or international level. So for instance, instead of having so many, and you can find some articles on the legitimacy of data processing in Article 5. So instead of having many legal bases for the processing of data, we have only two: consent and what other data, what other legal bases are provided for by the legislation of the country. So we leave basically to the consideration and for the legislator of the country to define what are other legal bases that can be served for the processing of the data. National security is something that I will not be able to pass on, because this convention, and it is very unique, covers all sectors, including defense and national security. And of course, it's important and it's very relevant for individuals that to guard against, and you remember this, that what I started with, this lawful interference, or to guard against unlawful interference or undesired interference by public authorities to the privacy, but also it guards against, it can guard data controller against too much hassling by national security and law enforcement agency, by giving them a legal base to refuse basically this kind of request if it doesn't comply with the conditions that are set out in Article 11. You can see exceptions and restrictions. So it is to the data controller to assess those conditions, and if that doesn't apply, they can refuse simply to comply with the law enforcement access to data or the national security, which can be a very important protection also for data controllers, for corporation in a transborder context. Data breach notification is also something that is not that strict than in other data protection legislation. For instance, there is no obligation, direct obligation, notifying individuals. It again leaves room of appreciation and consideration for the data protection supervisory authority, which has to be notified when a data breach occurs, and a data controller, how to handle the best the data breach notification, because we found that sometimes it can be counterproductive to go immediately to the media with data breach notification. Accountability is again something that I need to mention in Article 10, and especially the part which foresees that any states that are joining this convention or any other stakeholders that are basing their processing on it can adopt the accountability regime to the nature and the volume of data, the nature and scope and purposes of the processing, and where appropriate to the size of the controller and the processor, which again, I believe would be very sensible thing for corporation if they are involved in a transborder context. Of course, accountability foresees that they need to be able to demonstrate that they have taken some measures to comply with the convention and with the data protection requirements. But I think that today it's a common sense to, as I said, it's an obligation for states and for corporation. I will conclude by saying and citing a few other difference that, for instance, the EPA will not be able to process personal data in a cross-border context. It will be only the national DPA who will process this personal data, and based on Article 17 that you can see on the slide, it will be able to do cooperation or to enter into joint action with another data protection authority of another jurisdiction, but it will not be able to deal with the data which lies or which is in another jurisdiction. We believe that it's not across. Yes, and there are nuances. As you can see, there are nuances in these articles that you might have seen in other data protection legislation that are or can be interpreted as beneficial for trade context and for e-commerce environment. So we believe that it would not. I mean, if we take into consideration, if you take these measures into consideration and the convention itself within your trade negotiations, and of course, if your country is a party or wish to be a party to this convention, that you will come also to the conclusion that it will not represent a barrier to state, but truly a gain that can enhance free flow of data and by consequence trade and e-commerce. So with that, I will leave it like this. I have other points that I think that we can address in the Q&A section. Thank you very much for your attention, and back to you, Nick. Thanks.
Well, thank you very much, Peter. It seems that there are a number of features of this agreement that may be of use to negotiators in the JSI context. There are several one could highlight, but you've certainly pointed to several articles which seem like they might be fruitful for negotiators to consider. It's of interest, and it will come up later, I think, that the protection follows the data in your model, which is also a feature of trade agreements as it happens, for example, in the US-Canada trade agreement under financial services. That approach is used. It's also interesting that even though that this is an agreement that's centered in human rights, the default is that data may be transferred between parties. So it is possible to have a human rights centric approach to data protection and facilitate the free flow of data at the same time. Now for an Asia Pacific view, we turn to Clarice Giraud, the Data Privacy Project Lead of the Asian Business Law Institute, who happens to also be a French national. Over to you, Clarice.
Thank you, Nick. Thank you so much. And thank you so much for having me on board. I'm very grateful to the Canadian delegation, Ambassador de Boer, the Digital Trade Network for the invitation. So indeed, by way of a background, it might come in useful. I'm indeed a French national, and I worked for the French Data Protection Authority for a number of years as head of the international department, then counselor to the president of the authority as she was chairing the, what is today the European Data Protection Board. So as GDPR was being developed, so I have this strong European background, but also working in many transatlantic cases and with lots of counterparts worldwide. And over the past 6 years, I've been based in Singapore and running this project of convergence of data protection laws, data privacy laws in Asia, based in Singapore. And of course, Asia, Europe are very different. And therefore, I've had to sort of deconstruct my mindset, if you will, to understand the challenges of this region and propose solutions that are actually workable. And it's actually a challenge, but it's also, our work also has very interesting finding, which I'm really happy to share with you today. I think it's important, though, to recall first a bit of the background, the reasons why there is such a focus on data flows today, of course, and why countries pass more and more data protection laws, and governments are increasingly active in this space. Is that, well, we know that data flows now underpin our economies and virtually all the modern world, the functioning of the digital economy, cross-border business, but also essential state functions, increasingly so, and the COVID-19 pandemic has amplified this role. Ambassador de Boer mentioned, of course, working from home and all the digital implications of working remotely, telemedicine and whatnot. What I find extremely interesting and more and more important, actually, in the considerations of governments in this region that are working on the data protection laws and on data flows, there is an increased focus on public-private partnership around data sharing, therefore not strictly speaking a trade issue. And we must acknowledge that these issues of data flows go beyond trade matters. So just 2 weeks ago, I was reading that Indonesia, for instance, has requested clinical trial data from Brazil on the Sinovac vaccine because it just lacked the data for its own vaccination campaign. And that's just fascinating because it's typically its data flows. It's probably subject to Brazil's new data protection law, but then, it's data flows, but it's not covered in a trade agreement. But it's still something which is very important for governments to consider. And generally speaking, privacy expectations around data sharing by countries, by governments themselves, and the role of digital technologies at the heart of the public health response to COVID-19 play a very important role, certainly in Asia at the moment. Greater privacy expectations, but also because there's been a surge in cyber attack during the pandemic, and particularly in Southeast Asia. So that's a key concern as well. So because data flows underlie so many aspects of our lives, of course, the regulation of these flows intersect with an increasing number of areas and actors of regulation. And as someone who's been in data protection and privacy for 20 years now, I find it striking how all these issues, how the dimension of this data flow issue has evolved, because we see different worlds collide really, or at least meet where they did not meet before. So of course, different geographies. I mean, now these issues are truly global. For a very long time, these discussions have been largely led in a transatlantic setting. Let's be frank, this has changed dramatically, and I will explain how this is taking place in Asia. But also, these issues are being discussed in multiple forums, and there are lots of sources of regulation in very diverse domains. So trade, of course, but also competition and export controls, data privacy, digital innovation, law enforcement, judicial enforcement, and so on and so forth. And of course, depending on who you talk to, the country you're in, there will be very different approaches to data protection, to privacy, of course, and to data flows. And on top of that, the geopolitics of data flows have become complicated, let's put it this way. And in Asia in particular, we're really in a very interesting region to see these discussions develop. So I think we're all of us coming to the realization that the challenges which are being thrown at us are actually too complicated to be addressed by one forum and one type of actors alone. No one detains the universal truth, and yet there's no World Data Organization, there's no right forum to discuss all these issues in all their components. But in the meantime, there are still a lot of things that can be done. And one of these is actually to create opportunities for different worlds to meet and understand each other better. And being here in Asia, where lots of data protection legislations are actually more economic in outlook than purely human rights based, even though many jurisdictions actually have human rights based laws. It's very interesting to see how I've had to adjust my terminology sometimes, and again, tweak a bit my mindset to understand the person on the other side, so that I was sure that we were having a meaningful conversation. And I'm sure that the GSI negotiations will be fascinating in that respect, because you will have more of these sort of interpretation to make. And this kind of misunderstanding actually can impede a fruitful discussion on data flows and data protection worldwide. Just to give you an example, and then I'll really dive into the Asian developments. I hear the term data transfer restrictions used very much in the area of by trade negotiators, for instance, trade professionals. I don't think we would talk about data transfer restrictions in a data protection context. We would put conditions on data transfer, but the objective is not to restrict the transfer in itself. It's to ensure that the data can flow in a responsible manner. Likewise, when you say discrimination, well, you think discriminatory measures in trade, but we think discrimination in AI and algorithms, for instance. So we need to take time to understand each other better, and I think this kind of events just is just fantastic. And if we understand each other better, of course, all the initiatives on data flows that can be taken will actually reinforce rather than undermine each other. So I do believe very much in this kind, in the force of this kind of event. So from my perspective, what is the information that our work can bring to SWJ embarks in these GSI negotiations? Asian developments in the area of data protection and data flows are actually fascinating because they offer a kind of precipitate, if you will, of all the challenges and key points which need to be met collectively. The global context is that we see an explosion of the number of data protection laws worldwide, and that includes Asia. And we have a number of game changers on the horizon. China just released a draft personal information protection law. In the NPC. India has a draft data protection bill pending in Parliament, will be introduced next week or in 2 weeks' time. Indonesia should have finally data protection law. And of course, the United States is supposed to have a federal privacy law soon, because that was one of the promises of that of the Biden candidate Biden. And this is interesting because it reveals that despite different underpinnings, there are increased privacy expectations from the general public. And I agree with what Peter just said, which is that basically, I don't think anyone truly believes that data protection laws and data transfer provisions in data protection laws are actually truly barriers to trade. And I'll elaborate on that later. So the first laws in this region, Hong Kong, Japan, Australia, and New Zealand down there, and then later Singapore and Philippines, have basically tracked the basic OECD privacy principles roughly. And now we're in a phase where we're seeing the development of a second generation of data protection laws, where basically countries are catching up with with modern data protection principles and concepts. So with EU GDPR, definitely as a source of inspiration, but with many variations, and there are concepts that will come from Canada or Australia. It's basically a combination of all sources. But the trend is, though, comprehensive coverage, so law that covers both the public and the private sector. Extraterritorial reach, which is very significant because that means that businesses which operate cross-border can actually be subject to multiple data protection laws without necessarily being aware of it. Revenue-based fines that now are quite common and standard. Data breach notification requirements, privacy by design, privacy by default, privacy impact assessment. So fairly sophisticated provisions, also new rights like data portability and so on and so forth. And of course, new provisions on data flows specifically. So this is a very positive movement because it goes in the right direction, more data protection to meet the privacy expectations of individuals. It also creates challenges because all this happens, it's very confused actually. The movements are, everything is happening at the same time. So there's a lot of legal uncertainty. Laws are passed but not implemented. Laws are announced but never come out. Laws are basically enforced but never we don't know the outcome sometimes of enforcement actions. Implementing regulations take forever to come out and so on and so forth. So for businesses, that's a real problem. A lot of legal uncertainty. Also, key notions will not be defined, particularly in data localization provisions. There's also a lot of inconsistencies between laws, and this is what we have been working on at ABLI in particular, ABLI Asian Business Law Institute, my organization. Basically, where are the data transfer provisions in this region? What are they? Because we keep hearing that they're complicated, there are conflicts between laws, there is not enough overlap, they're not interoperable. At the end of the day, we thought, fine, we need to go down and dive into these laws to understand why, when there are overarching principles like the OECD privacy principle, the APEC privacy framework, and so many common references and principles that basically always trace back to the OECD principles, how come that there are still so many differences and businesses challenge, find it so difficult to actually comply. And so we've done this mapping exercise because there is no overarching structure of cooperation in data protection and privacy in this region that can do this work of basically checking the consistency of national legislation against an overarching framework, whatever it is. So we've done that work. We've mapped the ground. We've looked at all these provisions. We've reached out to law experts, practitioners, industry in this region to know the law, but also how it works in practice. And by doing that, we've extracted, well, indeed, we've highlighted the differences, but also the commonalities between these laws. And what we've seen is actually very consistent with what Peter was saying earlier. These provisions are quite workable. Contracts, for instance, are a standard mechanisms which is recognized for data transfers in virtually all jurisdictions. And by the way, this work we've done is publicly available for free on our website. I'll be happy to circulate it to the organizers so that they can send it on to you. It's a big comparative table on all data transfer provisions in Asia, very detailed, vetted by the regulators. And we have done an analysis based on that to highlight the differences, but also the many commonalities so that regulators can actually work together and maybe build solutions together. And our work has been, we've made inroads in a number of jurisdictions, so that's very promising. So in other words, there are differences, but they can be bridged. Excuse me. Now, the challenge for regulators in this fairly fragmented landscape, and I was very interested to hear Ambassador de Boer mention the fragmented approach to e-commerce regulations, because we have exactly the same problem in data protection. Fragmentation is the word that we hear all the time. And the question is how, and first of all, what are the problems that it raises? And regulators have come into that space by saying, okay, we see a greater interdependence between data protection frameworks. And this is a good thing because it enables a lot of cooperation between us. But at the same time, there are gaps in protection. that limit regulatory cooperation. When the scopes of the laws are different, for instance, well, you can't cooperate on the same facts, you can't transfer complaints. It blocks basically cooperation, and this is not satisfactory because it negates the very purpose of the data protection law in the first place. Now, the other good news is that not only can you find commonalities in practice, but regulatory networks are also getting stronger. And because there are more and more data protection laws out there, more data protection authorities, DPAs, can eventually contribute more meaningfully to this global conversation. Now, there are other challenges that cannot be solved overnight, like localization, law enforcement access to company data, the impact of FREMS2 in Asia Pacific. That's another topic. We can discuss that later. There's interesting work going on at OECD on this issue, so hopefully there can be some forums where these problems are being looked at. To close, just one thing. I believe that for the GSI negotiators, what would be important to look at is that there's been a multiplicity of initiatives to facilitate data flows and all go in the right direction. RCP, CPTPP, digital economy agreements, the Osaka track at WEF, all this goes in the right direction, but I've heard increasingly often that there are concerns of consistency as to all these initiatives, and which are build on one another, but are they truly consistent when they are implemented in practice? And I believe this is a discussion that maybe GSI negotiators should look at, because this will be a challenge for you also. How do we make this agreement a very strong one at a critical time for data flows? And so, to close, I think it would be fantastic if the work done by the GSI negotiators would basically accompany these trends, push towards greater consistency of laws, alignment on high standards of data protection and privacy, because this is what we see regionally and globally. And hopefully we can have reflections also on the right forum where these discussions can take place, because to be frank, I still don't see what the right forum is, where it is, who can co-organize all these discussions. So today's session is fantastic because it lays the ground for future discussions, and I'd be delighted to contribute further. I hope I haven't been too long, but thank you again for having me on board. Nick, over to you.
Well, thank you very much, Clarice. You've given all of us a lot to think about, and something of an alphabet soup problem as well as a consistency problem. I was struck by several things that you said, but among them that, and you may choose to comment more on this during the questions, probably some questions will be asked along this line, but it sounds that in Asia, despite the dissimilarities, binding corporate rules or private contracts between companies have turned out to be one of the most used ways to allow personal data to travel across borders without hindrance, even when it contains private information. And it would be interesting if there might be a lesson for the JSI negotiators when it comes to provisions in thinking about providing for that in the agreement. But now we get to speak to one of the negotiators herself, Katrina Ellis-Cannon from Canada. So over to you, Katrina.
Thanks, Nick, and thanks to everyone, and to Peter and Clarice for your very interesting presentations. And good morning, afternoon, and evening to everybody who's joining us around the world. As Nick mentioned, my name is Katrina Ellis-Cannon. I'm with the Services Trade Policy Division at Global Affairs Canada, and I lead a small but growing team on digital trade issues there. We really do welcome the opportunity to make a contribution on this important topic and to continue exchanging in an informal manner on some questions related to data-related provisions in free trade agreements, with a view to advancing our discussions in the Joint Statement Initiative. So I was asked to speak about the Canadian experience and approach to data provisions in our free trade agreements. As Ambassador DeBoer outlined and other speakers, and as we've heard many, many times, cross-border data flows are an intrinsic part of international trade. Trade depends on seamless and uninterrupted information flows between companies and across jurisdictions and borders. At the same time, we recognize public concerns around the vulnerability of personal data to hacking, identity theft, foreign state prying, and commercial misuse. This has led governments, including Canada, to regulate the collection, use, and transfer of data. While we certainly must find ways to ensure that governments can ensure the protection of personal information online, we must avoid creating unnecessary or overly burdensome requirements that limit the ability of companies from engaging in cross-border e-commerce. And this is particularly true for SMEs. There are very different ways, as we heard this morning, in which countries protect data. Some countries are quite prescriptive in how data should be protected, while others take a more laissez-faire approach and encourage businesses to adopt best practices. Interoperability and compatibility of data protection frameworks is important, as we just heard from Clarice, given the importance of international flows of data and information to the global economy. We are seeing an increasing demand from business for international rules around data flows and data localization. And we really do see the WTO Joint Statement Initiative on e-commerce as an opportunity to respond to these calls. A fragmented system of data protection creates burdens for businesses, leads to uncertainty among consumers as to how their data is being protected, and it creates challenges for the economy writ large. The level and nature of government control over data, including cross-border transfers, is at the heart of domestic and international discussions. We recognize that finding ways to bridge this gap in the Joint Statement Initiative will be challenging, but we will today. I'll speak a little bit about how we've approached it in our free trade agreements as one way of addressing this challenge. So in our model approach to digital trade provisions, we include obligations which allow for or do not restrict cross-border data flows. Together with obligations on data localization, these are some of the core obligations in our digital trade chapters. We have included commitments on cross-border transfer of information in the Comprehensive and Progressive Agreement for the Trans-Pacific Partnership, the CPTPP, as well as the Canada-United States-Mexico Agreement, known as CUSMA in Canada and USMCA elsewhere. So these obligations stipulate that a party will not restrict the cross-border transfer of information by electronic means, including personal information for commercial activities. First, I would like to emphasize, as with any trade agreement, it's important that these obligations be read in the broader context. They do not apply to government procurement or to information held or processed by or on behalf of a government. Secondly, the article also allows the parties to the agreements to take measures to achieve a legitimate public policy objective, such as privacy protection, so long as these measures are not arbitrary, unjustifiable discrimination, or a disguised restriction on trade, and are required to achieve the objective. This language was taken from the general exceptions of the GATS, which permits WTO members to adopt or maintain domestic measures to protect the privacy of individuals and the confidentiality of records. For Canada, it's important that the exceptions to the rule on cross-border information flows mirror the general exceptions of the GATS to maintain consistency with our current service commitments at the WTO and the relevant exceptions. For example, Canada, like many other WTO members, has taken commitments to allow foreign-based suppliers to provide data storage and processing services. To meet this commitment, it's clear that information has to be transferred across borders. This is equally true of all our cross-border services commitments in the GATS. We see this approach as providing governments with ample flexibility to maintain appropriate and robust domestic laws and policies around privacy. We currently achieve this in Canada through the Personal Information Protection and Electronic Documents Act, PIPEDA, which, among other things, governs the transfer of personal information across borders. With this approach and our free trade agreements, we are confident that Canada will be able to modernize and adapt our privacy regime, provided any requirements could not be regarded as constituting arbitrary, unjustified discrimination or a disguised restriction on trade. It is our view that this approach is a way in which we achieve an outcome in our free trade negotiations that ensures the movement of data and information across borders while addressing privacy concerns of businesses and individuals by offering members the ability to ensure the protection of data. In the context of our WTO e-commerce negotiations, we see incorporating the GATS general exceptions as a way to accommodate the different approaches to data protection. The GATS general exceptions already apply to privacy, not to mention other sensitive issues like protecting human health or maintaining public order. The approach would allow members to take on substantive commitments for the movement of data across borders, while providing for members to adopt or maintain robust measures to ensure the protection of that data. Such an approach, incorporating the exceptions to apply to commitments on data flows, it could also provide flexibility for those members who have yet to introduce measures to protect privacy and data online. I'll leave it there and look forward to hearing other perspectives during the Q&A. Thanks.
Thank you very much, Katrina. That was very, very interesting. I'm struck by how Canada's FTA experience. You have agreements with so many different jurisdictions when it comes to data protection and major trading partners. Yet, of course, you've managed to craft agreements which both protect privacy and increase trust, but also facilitate the free flow of data, which proves that it is not rocket science. It may be complicated, but it is not rocket science. We're now going to pause the recording so that we may take questions until a few minutes before the end. So we have almost half an hour. Well, thank you very much. And now for the closing comments, I turn to Alex Mora of the Digital Trade Networks Advisory Board and a lifelong tech entrepreneur himself. So over to you, Alex.
Thank you very much, Nick, for this opportunity. Ambassador Duber, thanks for leading this space. And thanks to your team and also to the panelists in this event. Allow me to address these final remarks in Spanish. I think it's worth to do it. En el siglo XXI, amigas y amigos, la importancia de las transferencias internacionales de datos y la seguridad jurídica que éstas deben tener es fundamental. Esto no es una exageración. Este acuerdo no puede ser ambicioso sin una cobertura bastante amplia y horizontal para transferencias internacionales de datos, incluidos los datos personales. Esto no es simple, pero seguramente es posible de lograr. Como exministro de Comercio y ex colega de ustedes, sé lo difícil que este tema resulta cuando se aborda en negociaciones. En mi pregunta sobre las pequeñas y medianas empresas solamente abordé una dimensión del problema, pero en realidad es clarísimo que hay muchas otras, algunas muy directamente relacionadas al comercio y otras no relacionadas al comercio. Lo cierto es que para que este acuerdo sea lo que queremos que sea, es necesario abordarlas todas tan ampliamente como se puede. Los negociadores seguramente pueden necesitar para ello de propuestas que no necesariamente están todas sobre la mesa. Y creo que será importante que ellos recurran a colegas, recurran al apoyo de muchos otros expertos en diferentes áreas para poder complementarse. Creo que desarrollar esta negociación a partir de confiar en excepciones que garanticen los espacios para proteger los datos personales y los datos en general no es el enfoque correcto. Necesitamos un enfoque positivo, donde el derecho a regular no interfiera con el comercio y donde las excepciones y las salidas creativas y locales no encubran entonces actos proteccionistas donde la información personal y los datos se conviertan entonces en moneda de cambio para ese proteccionismo. Eso no es lo que ocupa el comercio. Creo que tenemos que ser claros de que el riesgo de ese proteccionismo termina siendo el elefante en la habitación que todos vemos y que creo debemos señalar. Hemos visto cómo excepciones en el pasado, en muchas otras áreas, han terminado en obstáculos claros al comercio. Y esos obstáculos dañan especialmente a las pequeñas y medianas empresas y especialmente a los países en desarrollo. Hemos escuchado hoy una serie de buenas noticias, como Europa, la OCDE, los países de Asia, la Unión Africana han venido abordando este tema. Para mis colegas de América Latina, en especial, me preocupa que América Latina no se ha mencionado ni una sola vez en este seminario. Y esto claramente obedece a razones. Yo les quiero hacer, por favor, un llamado para que esas razones eventualmente puedan ser atendidas y controladas. Creo que la protección de datos es un derecho fundamental y no excluye que pueda convivir, coexistir de forma sólida con acuerdos de naturaleza comercial. Recordemos que esto no es fácil, pero ir y venir a la luna no lo fue, y generar una vacuna para esta pesadilla del COVID que estamos viviendo en unos pocos meses, en menos de un año, no es fácil. Seguramente lo que aquí está entre manos es menos difícil que estas dos cosas. Y por tanto, yo confío en que ustedes lo van a llevar adelante. Espero que se pueda aprovechar la oportunidad. Sabemos que las empresas tendrán que invertir. Mis empresas pues tienen que ir y contratar abogados en todas partes para poder resolver estos problemas, pero hay muchas empresas que no lo pueden hacer. Y estas empresas merecen participar en el comercio, merecen crecer digitalmente y merecen ser actores en esta negociación. Así que los insto para que el hito de un texto consolidado a principios de este año y un acuerdo durante este año 2021 se haga una realidad. El mundo va a necesitar de lo que ustedes están haciendo y va a necesitar de los beneficios de este acuerdo en la medida en que nos recuperamos del proceso del COVID y en la medida en que abordamos de manera contundente la recuperación económica. Como miembro del Consejo Asesor del Digital Trade Network, espero que esta sesión y nuestro aporte haya sido valioso. Quedamos a sus órdenes, nuestra red está a sus órdenes y les agradecemos en particular al embajador y a la delegación canadiense por participarnos y dejarnos apoyarles en este proceso. Muchas gracias.
Thank you very much, Alex, and to all the panelists, to the Government of Canada, Delegation of Canada, for kindly co-sponsoring this. Last but not least, to the interpreters from the WTO, and to all of you who joined us today. Thank you very much.